An assessment arrives from the ATO, and the number is wrong. You are sure of it. What most taxpayers do next is nothing. They assume that once the ATO is spoken, the matter is settled, and the only option is to pay and move on. That assumption costs Australians a great deal of money every year. I am Benedict Youn, tax lawyer at Australian Tax Experts, and in this presentation, I will walk you through the objection process step by step, the deadlines, the grounds, the drafting, the ATO's decision, and where the fight goes if that decision is against you. Because an assessment is not the final word. 4 numbers frame your rights. 2 years, the time most taxpayers have to object to an income tax assessment. Individuals and small business entities get 2 years from the notice of assessment. Other taxpayers get 4. 60, the number of days you have to take the matter to independent review after the ATO decides your objection. That one is strictly enforced. 2024, the year the tribunal system changed. Since the 14th of October 2024, objection decisions are reviewed by the Administrative Review Tribunal, the ART, which replaced the old AAT. And $350,000 plus, the capital gains tax liability one of our clients faced, reduced to nil through the objection process. We will come back to that one.
Start with the principle. Australian tax law gives every taxpayer the right to object to an ATO assessment. This is not a favour the ATO grants. It is a formal legal mechanism, and it exists precisely because assessments are sometimes wrong. 2 things follow from that. First, an objection is a legal process, not a complaint. It is not the place to express frustration about how the audit was conducted. It is a structured challenge to the correctness of the assessment itself. And second, handled well, it genuinely changes outcomes. Objections succeed. Assessments get reduced, sometimes substantially, and sometimes withdrawn entirely. The taxpayers who benefit are the ones who treat the process with the seriousness it deserves, and who move quickly. Here is the whole journey on one slide. It begins with the assessment, the ATO's notice setting out what it says you owe. If you believe it is wrong, the next step is the objection, a written legal challenge lodged within the objection period. The ATO then reviews it and issues an objection decision, allowing your objection in full, allowing it in part, or disallowing it. And if that decision goes against you, the matter can move to independent review. The Administrative Review Tribunal, or the Federal Court, commenced within 60 days. 4 stages, each with its own rules and its own deadlines. Let us take them step by step. Step 1. Know your deadline, because time is the hardest edge of this process. For an income tax assessment, most taxpayers have 2 years from the date the notice of assessment was given. That covers individuals and small business entities. Larger taxpayers have 4 years. But be careful. Many other ATO decisions carry much shorter objection periods, in some cases only 60 days. So the deadline must always be checked for the specific decision in front of you. And if the deadline has already passed, you can ask for an extension of time, but the ATO is not obliged to grant one, and extensions are never guaranteed. The practical rule is simple. The moment you receive an assessment you disagree with, get advice. Time you spend deciding whether to act is time you cannot get back. Step 2. Define the target. An objection must identify specific grounds on which the assessment is incorrect, precisely where and why the ATO got it wrong. The common grounds fall into familiar categories. The ATO has misapplied the law. It has reached factual conclusions the evidence does not support. It has failed to consider relevant evidence altogether, or it has issued the assessment outside the time limits that bind it. Whatever the ground, it must be reasonably arguable, meaning there is a genuine legal and factual basis for the challenge. You do not need certainty of winning, but you do need a credible position you can articulate. That early, honest assessment of your grounds is where a good advisor earns their fee, before a dollar is spent on the fight itself. Step 3. The document itself. The objection is a written case lodged with the ATO, and its quality matters enormously. It must state the grounds clearly, support them with factual submissions, and anchor them in the applicable legislation and case law, because a reasoned legal argument gives the ATO officer a defensible path to changing the position. Here is what we see too often: an objection that senses the right outcome, but cannot articulate the legal reasoning behind it. That kind of document gives the ATO little reason to move, and strong cases get lost that way. A well-drafted objection does the opposite. It presents a compelling, logical case that is difficult to dismiss. The facts win cases, but only when the drafting lets them.
Step 4. After lodgement. The ATO reviews the objection and issues its decision. Allowed in full, allowed in part, or disallowed. There is no fixed timeline, and complex matters can take many months. During that period, the ATO may ask for further information or request meetings. Handle these interactions carefully. They are part of the contest, not a formality, and your representative should be present at any meeting with ATO officers. One more thing many taxpayers do not expect. Lodging an objection does not put the underlying debt on hold. General interest charge continues to accrue on unpaid amounts. The ATO does offer arrangements, such as 50-50 arrangements, that limit recovery action while the dispute runs. But the interest clock keeps ticking. Factor that into your strategy from day one.
Step 5. If the objection is disallowed, the fight is not over, but the clock resets, and it is short. A review or appeal must generally be commenced within 60 days of the objection decision. 2 forums are available: the Administrative Review Tribunal, which replaced the old Administrative Appeals Tribunal on the 14th of October 2024, is the less formal and generally less expensive option, and it reviews the matter fresh, on its merits, rather than merely checking whether the ATO followed process. The federal court applies a stricter legal standard, with higher stakes and a costs risk to match. Which forum to choose is a genuinely strategic decision. It depends on the strength of your evidence, the legal questions involved, and the value at stake. And it is a decision to make with a tax lawyer, not by default. Let me show you what this process can achieve. A client came to us facing a capital gains tax liability of more than $350,000, built on an ATO private ruling position. On first look, the case appeared insurmountable, the kind of assessment most people would simply pay. We disagreed. We built an objection that combined rigorous legal analysis with precise tax calculation, challenging the foundation of the ATO's position rather than nibbling at its edges. The result? The liability was reduced to nil, not negotiated down, eliminated. The difference between paying $350,000 and paying nothing was the objection, the grounds we chose, the evidence we marshalled, and the way the case was put. At Australian Tax Experts, tax lawyers and accountants run the objection process as one team, end to end. We start with a grounds assessment, an honest evaluation of whether your objection is reasonably arguable, before you commit money to the fight. We handle drafting and lodgement, objections built on legal analysis and precise calculation, lodged inside the deadlines. And if the ATO disallows the objection, we represent you at the Administrative Review Tribunal or the federal court, with the forum chosen strategically rather than by habit. The objection process looks straightforward on paper. In reality, it is a legal proceeding with significant financial consequences, and the ATO's officers handle objections every day. You should have someone on your side who does too. If you have received an ATO assessment you believe is incorrect, remember, time limits apply and they are unforgiving. Contact Australian Tax Experts today to discuss your matter in confidence. Visit australiantaxexperts.com.au/contact. Thanks for watching, and remember, this presentation is general information only, not personal tax or legal advice.